All right, good evening. I think we'll get started and we'll let people fill in a little bit as they're coming in. My name is Jonathan Sklarczyk. I'm an Assistant Attorney General at the Attorney General's Office, and I work in the Division of Open Government. And today we're conducting a training on the open meeting law. And this is actually one of 7 regional trainings that the Attorney General is conducting across the Commonwealth. So I certainly thank you for attending today, and I certainly hope this will be a good learning experience and will be fruitful. What I'm going to do with this presentation through this PowerPoint is go through all the various aspects of the open meeting law and really cover everything that you would need to know as a member of the public or as a member of a public body serving and following the open meeting law. And I'm going to really focus also on some of the changes to the open meeting law, and I'll talk a little bit about that. In this presentation, we'll talk about the Attorney General's role in the updated open meeting law. And we're going to talk about some of the actual definitions within the open meeting law, who's covered by the open meeting law, what conduct is covered by the open meeting law. And then we're going to talk about what activities, such as keeping minutes, entering executive session, keeping records, and we're going to talk about the complaint process and the Attorney General's role in that. Before I proceed, a couple of sort of ground rules. We're going to take some Q&A at the end, and so hopefully you've picked up some index cards that were up front. Feel free throughout the presentation to write down questions as you come up. Hopefully I will answer them throughout the presentation, but we're going to leave all questions to the end so I can get through the entire presentation. And then we'll take a little break. I will read through the questions, we'll kind of reconvene, and I'll answer as many as time permits. I cannot answer any questions on any pending complaints, anything the Attorney General is currently investigating. And likewise, I can't answer any questions that are specific to an incident that may have occurred that could be the subject to our investigation or enforcement. So I couldn't answer a question that says, I was at a meeting last week and the board did this and this. Is that a violation of the open meeting law? I really can't speak to that. I can only speak generally about the open meeting law and any questions you have about this presentation. So, going right into it, the open meeting law is about a balance between government transparency and government efficiency. There we go. And so the purpose of the open meeting law is to recognize this balance and to ensure that meetings are transparent, that meetings of government are open to the public. The public can witness policy being made. It ensures transparency by requiring that public bodies post notice of their meetings. Also requires that the deliberations, that the communications between the board members are conducted in an open meeting where the public has access to witness. On the flip side, it also allows for the government to efficiently operate by having certain purposes to enter executive session, to go behind closed doors and conduct business outside of the public view. And we're going to talk about that, the whole executive session process, which are the proper purposes and the proper procedures a public body must follow in order to enter executive session. And then the open meeting law also allows efficient operation of government by allowing for certain documents to be held as confidential outside of public view for a certain period of time and for certain reasons. I'm going to talk a little bit about the Attorney General's role before going into the law itself. And just a quick background on the open meeting law and sort of why we're conducting these presentations now. The open meeting law has been on the books for a long time and was really codified in its current form in the 1970s in the Watergate era, and remained largely unchanged except for minor tweaks here and there until 2009. The Ethics Reform Act of 2009 really took a new approach to the open meeting law, and it took effect on July 1st of 2010 and created a lot of really broad changes. A lot of the open meeting law still remains the same. A lot of the main concepts about the open meeting law, the need for transparency, the requirement that public bodies are posting notice, are holding open meetings, all remains the same. But I'm going to highlight some of the changes and things that are important for you to know. Now, one of the changes was to create enforcement authority to give the jurisdiction over the enforcement of the open meeting law to the Attorney General. The Attorney General established a division of open government to interpret and enforce the open meeting law, and that's the division I work in. Part of our mandate is to educate and train public officials and members of the public on the open meeting law. We take that role very seriously. It's the Attorney General's belief that the majority of violations of the open meeting law are not intentional, but are rather due to a lack of understanding of the requirements of the law and a lack of education. So we certainly take our role to educate the public very seriously. We also provide guidance on the open meeting law requirements. We do that through our website. Our office responds to inquiries. We promulgated regulations that took effect on October 1st of last year, which provide further guidance and interpretation on the open meeting law, and I'll talk a little bit about there. And we also address open meeting law complaints, the actual complaint process I'm going to talk about at the end of the presentation, and we bring in enforcement actions, and we can make findings and issue orders as well. So I talked about the open meeting law as part of the Reform Act of 2009. But a lot of it did remain the same. Meetings, as I said, must still be open to the public unless the public body enters executive session. And the executive session purposes remain largely unchanged. There's 10 purposes that for the most part have not changed, and I will go through those. Meetings have to be posted, and they've always had to be posted, but there are some new requirements regarding notice posting. Public bodies may still enter executive session, and public records still have to be retained. And there's some confusion with the changes. There was always a requirement that records used by a public body are public records and do need to be retained by the public body. But the open meeting law really clarified that and added some requirements in this law. There's still an alternative complaint process where 3 citizens may file a complaint in Superior Court. And this existed under the old law. Rather than going to the district attorney, or in this case now to the Attorney General, citizens can go to court and seek enforcement action. And the Attorney General retained enforcement over state public bodies. Under the old open meeting law, a local public body, Board of Selectmen or school committee, if there was a violation, the complaining party would file their complaint with the district attorney. And now all enforcement is with the Attorney General. So what's new? Centralizes the enforcement with the Attorney General's office, as I just explained. There's a new division of open government that was created as a result of this law. And it created an Open Meeting Law Advisory Commission, which is a 5-member board at the state level, which advises the Attorney General on regulations. Also now there's additional notice requirements, which I'm going to talk about a little later. There's enhanced record-keeping requirements. There's now more details can be required in meeting minutes, and I'll talk about that. Also now, complaints, the open meeting law requires now a process for remediation at the local level or at the public body level for a complaint. Under the old open meeting law, if a member of the public wished to complain that there was a violation of the open meeting law, they would file that with the district attorney at the local level or with the Attorney General at the state level. Now, complaints are required to be filed with the public body first before they're filed with the Attorney General. So I'm going to talk about that in the complaint process. And finally, there's a requirement that members of public bodies be familiar with this law. And there's a specific certification requirement, and this is new. There's a form that you have to fill out as a member of a public body within 2 weeks of your qualification for office, which is in 2 weeks of either your oath of office or starting your term in office, that you've reviewed the open meeting law, you've reviewed materials that have been provided to you, hopefully by the municipal clerk, and you've signed this form saying that. So let's go right into the statute itself and talk about what are the definitions, what are the requirements of the open meeting law. And the first question is, what bodies are subject to the open meeting law? What entities? And the answer is it's a public body. Public body is defined as a multiple member board, commission, committee, or subcommittee, however created, elected, appointed, or otherwise constituted, established to serve a public purpose. This is a very broad definition. This covers a lot of entities. First of all, it has to be a multiple member board. One person is not a committee, and they're not subject to the open meeting law. But a multiple member board, so 2 or more, may be. Also, it doesn't really matter what it's called. If it's a committee, a commission, a working group, it doesn't really matter. But if it meets this definition, it may be subject to the open meeting law. Also important to note are that subcommittees. Subcommittees are in fact public bodies. Subcommittees are required to follow the open meeting law, including posting notice and taking minutes and holding open meetings. So if there's a 7-member committee and they appoint 3 members of that committee to be the finance committee or the technology committee, that committee, then that subcommittee is also a public body in itself. So it's a broad definition. There are some statutory exclusions. First of all, in the open meeting law, the legislature and its committees are excluded from the definition of public body. Also, our bodies of the judicial branch, so juries, for example, are not subject to the open meeting law. They're not public bodies. Then there's a couple legal definitions throughout this presentation, and I'll try to do my best to break that down, so I apologize for legalese. Bodies created by a constitutional officer solely to advise the constitutional officer. That refers to the 6 constitutional officers in the state: the governor, lieutenant governor, secretary of state, the treasurer, the attorney general, and the state auditor. They can create a committee solely to advise them, and that is not subject to the open meeting law, but anything that's broader may be. Certain bodies may not serve a public purpose, and they're not subject to the open meeting law. If there is a department that sets up a party planning committee for someone's retirement, it's probably not subject to the open meeting law. It probably doesn't really serve a public purpose. And then here's one of the legal definitions: groups that are not established with the jurisdiction to make decisions or recommendations collectively. And this is something we read into the open meeting law, that there is a requirement of collective action. There's a quorum requirement, that the board is actually acting collectively. In other words, a focus group may not be subject to the open meeting law. A board of individuals who are giving individual feedback in response to another entity or a person or a committee, it may not be subject to open meeting law. But where there's a board that's acting collectively, that's coming to a consensus, that's making a policy recommendation, those are more likely to be subject to the open meeting law. Now, in addition to these exclusions, there's one other exception, which is created by the Massachusetts Supreme Judicial Court in the case of Connolly versus the Hanover School Committee. And I'll read that exception and then I'll explain a little bit of what this is about. It says, where a public official creates a committee to advise that public official on a decision that he or she has sole responsibility for, the committee or board is not subject to the open meeting law. So what happened, and I'll try to explain this by talking about what actually happened in this case. In the Hanover case, in the Connolly case, the superintendent of schools had the authority to hire a principal. The superintendent could have just interviewed candidates and hired a principal. However, the superintendent decided to create a committee to interview applicants. And the committee involved school committee members, it involved members of the public, teachers, parents. And that committee met and recommended a candidate to the superintendent, who the superintendent then chose. Now, the superintendent did not have to create that committee. The superintendent had the sole authority to appoint the principal. And so the Supreme Judicial Court in Massachusetts said that if a public official has the sole authority to make a decision, then they can create a committee, and creating that committee does not bring it under the open meeting law. So it is a somewhat narrow exception. It's not where a committee, it has to be where an individual creates a committee. So if the school committee had the authority to appoint a principal, and the school committee created a search committee, that committee would be a public body. But where an individual has the sole authority to make a decision, they can create a committee to advise them on that decision, and that committee is not subject to the open meeting law. So that's the one exclusion that's created by the courts. But otherwise, it's a very broad definition. So let's discuss some examples of public bodies. At the state level, and there are different levels of public bodies, and where this is important is for the most part in the notice posting requirements. But at the state level, there's the Open Meeting Law Advisory Commission, which I spoke about a moment ago. The reason that's a public body is it's created by statute. It's created by the legislature, and it's within the executive branch. Also, the Board of Library Commissioners is a public body at the state level. The Board of Higher Education, these are state public bodies. At the local level are the bodies that we tend to know about in our neighborhoods, in our towns: the Board of Selectmen, the City Council, the School Committee, the Planning Board, Board of Health, Conservation Commission. At the regional level, there are regional school committees, regional water commissions, regional planning commission, and at the county level, where there's still county government, there are boards of county commissioners, county retirement boards, county charter review commission. These are all government entities that are multiple member boards that are public bodies. Now, on the other side, there are some examples of, here are some examples of entities that are not public bodies. Now, we said that the state Senate and the House of Representatives, those are excluded by the statute itself. The Judicial Nominating Commission is a commission advising the governor. And the Massachusetts Municipal Association is a private entity. It's a private organization, and it's not a government entity. It's a nonprofit. At the regional level, a regional high school boosters club may not be subject to the open meeting law because it's likely a private organization organized by parents and not actually part of the school and not part of government. Similarly, Neighborhood Watch Association and parent-teacher organization, those may be private organizations or nonprofit organizations. And then Republican and Democratic town committees, those are political organizations and not considered government entities that have to follow the open meeting law. Now, there are two other important definitions to be aware of. We know that public bodies are the entities that are subject to the open meeting law, but then the question is, what are the activities subject that trigger the open meeting law that members may conduct? And that's deliberation and meeting, and those two definitions are sort of read together. But I'll start with deliberation. Deliberation is an oral or written communication through any medium, including electronic mail, between or among a quorum of a public body on any public business within its jurisdiction. There's a lot in that definition, and it is very, very broad. First of all, it's an oral written communication through any medium, so certainly email is a deliberation if it's between or among a quorum. A quorum is generally a majority of the board. It can be defined differently if it's defined by statute or some other rule, so some boards might have more than majority as a quorum, but generally it's the majority of the members. So for a 7-member board, it's 4 as a quorum. And so it's any communication. It doesn't necessarily have to be just a vote or something that's geared toward a vote. It's any communication on any business, any public business within that body's jurisdiction. So pretty much any communications between or among a quorum on anything that has to do with the public body, more likely than not, that's going to be deliberation. Now, there are some exclusions. First of all, distribution of a meeting agenda, scheduling of procedural information. So if the chair sends out the meeting agenda for next week's meeting to all the board members via email and says, here's the agenda for next week, please review, that's fine. That's not a deliberation. Similarly, if the chair sends out an email saying, I'd like the board to meet next week, when's everybody available? That's fine, it's scheduling, they're not discussing anything substantive that the board reviews. Also excluded is distribution of reports or documents to be discussed at a meeting. However, the distributor should not express the opinion of a member of the public body. So in other words, it's okay to distribute a document that says, and here's a report, please review it, we're going to consider this next week. It's not okay to say, here's a report, please review it, and I hope you vote it down, or I hope we accept this. Any expression of opinion that gets to the substance would be a deliberation. So it's very limited. It's really in sort of just for housekeeping, for scheduling, for distributing documents. I generally recommend that if you're a member of a public body or you're a chair and you're going to send something over email, I would always blind carbon copy the members, because you're going to prevent someone from hitting reply all and expressing an opinion that goes to all the other members and then starts a deliberation process. So it's generally a good idea to always blind carbon copy a board if you're going to email them en masse. So I give you the definition of deliberation, and here's the definition of meeting. A meeting is a deliberation by a public body with respect to any matter within the body's jurisdiction. So certainly, if there's a deliberation, in order for it to be a legal deliberation, it has to occur during a meeting. Now, there are some exclusions to the definition of meetings. An on-site inspection, provided there's no deliberation. So a board could go to an on-site inspection, could travel to a location for an inspection, but they cannot deliberate. They cannot communicate between or among a quorum on any matters within that board's jurisdiction. So it certainly makes on-site inspections very difficult when there is a quorum present. So that's something to keep in mind. Pretty much they can observe, they may be able to ask questions of people at the site, but they can't discuss between and amongst each other if there is a quorum present. Attendance by a quorum at an event, provided there's no deliberation. So this was some confusion in the old open meeting law. Well, what happens if there's 5 selectmen and 4 are at the town party, at the holiday party? Can they not be in the same room at the same time? It's certainly appropriate for a quorum to be there to attend any event, so long as they're not deliberating. So if there's a quorum attending tonight, that's fine. They can participate in the event, but they can't discuss between and amongst themselves any matters within their jurisdiction. Attendance by a quorum at a meeting of another public body, provided there's no deliberation. So if the Board of Selectmen are holding a meeting and the school committee want to attend, they can do that as members of the audience, and they can speak to the Board of Selectmen if the chair recognizes them, but they cannot communicate between and among the quorum and the school committee. If they want to have a joint meeting, then they would have to actually post joint meeting and actually have both bodies meeting. But if a quorum of the school committee simply wants to attend, a Board of Selectmen meeting, they can do that without it being a meeting of the school committee, provided there is no deliberation. Here's another one of those tricky legalese ones. All right. Meeting of a quasi-judicial board for the sole purpose of making a decision in an adjudicatory proceeding. So what this means is, first of all, this only applies to state public bodies. There are certain state public bodies that are sitting in a quasi-adjudicatory capacity, meaning that they're making some determination about somebody's right, maybe revoking a license. And they can actually meet behind closed doors, and it's not actually a meeting, only for the part of making a decision. They still have to have a public process prior to that. That only applies to state public bodies. So a zoning board of appeals or conservation commission at the local level, board of health, they would not be able to use this exception. And finally, town meeting. Town meeting is not a meeting. However, town meeting is a public body. Whether it's an elected town meeting or it's the entire list of registered voters, the actual town meeting that occurs once a year or during special town meetings, that's a town meeting by statute, is excluded from the definition of meeting because it has its own requirements for posting and keeping records. But the town meeting is still a public body. So if you had an elected town meeting and that town meeting created committees, those committees would be public bodies. So we know what public bodies are, and we know what a deliberation is and that what a meeting is. And that deliberation has to occur at a meeting, and if it doesn't, it could be a violation of the open meeting law. So if a public body is going to have a meeting, they have to post notice. Now, except in an emergency, a public body must post notice of a meeting at least 48 hours in advance of that meeting, excluding Saturdays, Sundays, and legal holidays. The notice must include the date, time, place of the meeting, and the listing of topics the chair reasonably anticipates will be discussed at the meeting. And this is a new requirement under the open meeting law. And topics should give enough specificity so that the public will understand what will be discussed. So under the old open meeting law, it was pretty much acceptable to post a notice that just said that this board is meeting at this time at this location. Now there's a requirement that the chair is actually going to list, sometimes it's called an agenda, but here it's just called a listing of topics. They're actually going to list each topic that the chair anticipates will be discussed, at least 48 hours in advance of the meeting. And there has to be enough detail. It's not okay to say new business, old business. Those certainly can be categories of topics, but there has to be sufficient detail so that a person looking at this meeting notice would understand what it is that the body is going to be discussing. If there's a certain piece of property, they should list that property and the address. If there is an appointment to a position, they should list the position and who's up for the appointment. Really as much information as possible so that the members of the public will understand what it is this public body is going to consider. Now, an emergency is a sudden, generally unexpected occurrence or set of circumstances demanding immediate action. And in an emergency, a public body should post notice as soon as reasonably possible prior to the meeting, but they don't have to wait 48 hours. So we consider a good example of an emergency to be a water main break, something where it requires immediate action for either the public health or public safety. The public body cannot wait 48 hours. They have to have a meeting, so they're required to post as soon as reasonably possible. Certainly as soon as they're aware they're going to need to meet and they know what the time and location is. It's not okay to call it an emergency because, well, you just found out that half the board members are on vacation next week, so we have to meet tonight, or something this sort of just came up. Or there's a deadline and the members of the public body sort of let it go, and now if they don't meet tonight, they're going to miss some opportunity, miss some deadline. Generally, that's not going to cut it. It really has to be an unexpected circumstance, and it has to demand immediate action. Usually it's some threat to public health or public safety. Because otherwise, you're taking away the public's right to have sufficient notice that this meeting will occur and what the topics will be. We get a lot of questions about the sort of anticipated topics by the chair and the 48-hour requirement, what that means, and what happens for topics that sort of come up within 48 hours. Now, because this requirement is that the chair has to list all the topics the chair reasonably anticipates 48 hours, very often topics do come up within 48 hours. It is okay for a body to take up any topic that was not reasonably anticipated by the chair 48 hours that wasn't on the meeting notice. If it was reasonably anticipated by the chair, more than 48 hours, and it was not on the meeting notice, they cannot address that issue. But if it was within the 48 hours, so if, in other words, they're at a meeting and somebody raises their hand and brings up an issue and the board decides they want to take that up, they can do that. That's not a violation of the law, so long as that was not anticipated or reasonably anticipated by the chair. I hope I'm making this clear, because it's a little tricky. However, the Attorney General's office strongly encourages public bodies to postpone consideration of any topic that was not on a meeting notice. So even though there may be a right under the open meeting law, or it may not be a violation of the open meeting law to take up an unanticipated topic, if it's something that's of any concern to the real concern of the public, it's controversial, if it's something the public may be unaware of, we strongly recommend that public bodies postpone that any discussion or action on that item until they can put it on a meeting notice. And that's really just the best practice. So we talked a little bit about what needs to be in the notice, but then there's the process of actually posting. So local public bodies must file the notice with the municipal clerk. And the notice must be posted in a manner conspicuously visible to the public, including persons with disabilities, at all hours in or on the municipal building where the clerk's office is located. So this is also new under the open meeting law. This is requiring a 24/7 notice available to the public all times, day and night. Now, one thing that the law did allow is it authorized the Attorney General to permit alternative notice posting methods if the Attorney General found that there were methods that would provide better notice to the public. Last year we had a public comment process. We took a lot of feedback, and we did issue regulations with a determination that there were alternative notice postings that would provide better notice to the public. One of those is the municipal website. So municipalities have the option to choose to post to their website instead of posting on a bulletin board or in some manner at the city clerk's office or in the town hall. That's available 24/7. A lot of municipalities have in fact done that. They're just required to notify our office that they're choosing this alternative, that they're choosing a website. And then they have to post it on the website. They keep a copy at the clerk's office so people can still come in and actually see a hard copy during regular business hours. And they just need to have a little date stamp when it's posted to the website so people know when this meeting notice was posted on a website. There are other alternative options that we provided. There's several more. And if you're interested in those, I suggest taking a look at a website. You can kind of read. They include cable television as well as an alternate building that's open 24 hours, like a police station or a fire station. At the county, district, and regional level, at the regional and district public bodies, they have to post a notice in each and every town within the region or district in the manner prescribed for local public bodies. Or, thanks to our regulations, they can choose to post notice to a website. So if they're not using the website, if they're using the statutory method, if it's a regional public body with 25 towns within the region, they have to post notice in all 25 towns in order to post a meeting. So it can be a little challenging. So we have provided the website as an alternative. So, also for regional and school districts, the secretary of the regional school district is the clerk of the school district and shall file the notice with the clerk of each city or town within the district or may post to a website. For any of these, if the public body is choosing a website, they have to notify the Attorney General's office of the website location and that they're going to post notice to the website, but they don't need to send every notice to us, just once letting us know where that location is. For the county level, for county public bodies, they must post notice with the office of the county commissioner and a copy of the notice posted in a manner conspicuously visible to the public at all hours in a place or places designated by the county commissioners. Or, of course, thanks to regulations, they may post to a website. So we try very hard to provide alternative options for every type of public body. The websites, I think we're seeing more and more, but there are still a lot of municipalities that do have a just physical bulletin board, or they may have a binder with all of the meeting notices available, and those are still proper and legal methods for posting notice. At the state level, the state public bodies are actually required by statute to post to a website. And every state public body is required to notify our office of the website location. And then they're required to send a copy of each and every notice to the Regulations Division of the Secretary of State's office. And if you're here as part of the public body, part of the state public body, this is the address you would need to send each and every copy of your notice to. So some common concerns. Public bodies are encouraged to update the notice when made aware of a new topic within a 48-hour period before the meeting. So if it's 48 hours before the meeting and then 40 hours before the chair is aware of a new topic that wasn't anticipated, as I said earlier, it's still something that's appropriate for the body to consider. But they should update the meeting notice as soon as they're aware that there's a new topic. That's something that we encourage, particularly if they plan on actually taking action on that item. Chairs should also not post notices so far in advance that there's a high likelihood that new topics will arise. I've seen a couple public bodies where they've said, here's our meeting notice, it's for the entire year, second Tuesday of every month, here's our 3 items. That's probably not going to cut it. You certainly can put out a notice that says we meet on the second Tuesday of every month, and here are the topics we generally consider, and that's fine to give people some notice about what your schedule is. But that wouldn't be sufficient legal notice under the open meeting law. There has to be some clear level of listing of topics that are actually anticipated for that meeting, so members of the public will know what the public body intends to discuss. Chairs are also encouraged to work with the municipal clerks to enable sufficient time for posting, and that's pretty important. And we got a lot of complaints from clerks who say, well, you know, they sent it to me at 49 hours before their meeting, and I didn't get to it till 40 hours before the meeting. Ultimately, the public body is responsible for that posting. They have to file with the clerk, and if the clerk doesn't post it, it's the public body that's liable. The public body can't have its meeting if its notice didn't get posted 48 hours before. So we encourage public bodies to work with clerks and to understand what the clerk's schedule and requirements are. Some clerks are in small towns and they don't work on Fridays, or certain days of the week they're only open till noon. So it's important to know their schedule. One thing I recommend is generally to just avoid sending meeting notices 48 or 49 hours before a meeting. Try to have self-imposed at least 72 hours before, so you can give the clerk a full day, whether the email is backed up or the clerk didn't get to it. Give them a day. You can follow up with a phone call, but it's really, really important to work that out, because the clerk may make a mistake, but ultimately the public body is the one that's going to suffer. Meeting cancellations do not require any real notice. There's no 40-hour notice requirement. We just recommend that if a public body is canceling a meeting, they update the notice as soon as they're able to. And meetings that are canceled and rescheduled must still comply with all the notice requirements of the open meeting law. So it's not okay to cancel a meeting the day of and then say we're just going to meet tomorrow. You still have to have a 48-hour notice posting. It's also not okay to continue a meeting. If the meeting is going really late, it's 11:30, and the public body wants to continue it to the next night, they can't do that. There has to be a full new notice 48 hours prior to the meeting, to that continued meeting. A public body can have, sort of anticipate that a meeting will go 2 nights. And 48 hours before the meetings, post for 2 nights, and if they get everything done the first night, then cancel the second night. And that would be appropriate because they've given the public adequate notice. Just a quick note on accessibility for meetings and in general. Public bodies must continue to abide by the applicable state and federal laws that govern accessibility for the disabled. And in particular, public bodies should pay attention to the Americans with Disabilities Act with the Federal Rehabilitation Act of 1973, and there are some state constitutional provisions as well. This can be tricky to navigate, and so our office, the Attorney General's Civil Rights Division, has offered to provide assistance, be a resource to any public body that may be having challenges in meeting accommodation or not sure what the requirements are under these statutes and these laws. So we encourage you to reach out to our office and to our Civil Rights Division. In terms of reaching out to our office generally, there's a hotline number at the very back of this presentation. It's on the last page, and we'll get to it at the end. But that's a number to call anytime you have any question or seek any feedback or advice regarding the open meeting law. Public participation. Now, the public may attend any open meeting. However, there is not an absolute right to participate in every meeting. And this is something that does cause a lot of confusion, where people, members of the public, may believe they have a right to speak at an open meeting. But that's not actually the case. The public may not address the public body without permission of the chair or otherwise disrupt a meeting. And we certainly encourage chairs and public bodies to allow for public participation. It's generally good. It's good government. It's good policy. But it's not required, and it's at the discretion of the chair. The public may make an audio or video recording of an open session upon notification of the chair and subject to reasonable requirements. And the chair also must inform other attendees of the recording at the beginning of the meeting. So I recommend that if you're the chair of a public body, one of the first things you do when you open the meeting may be to ask, is there anyone here today who wishes to record this meeting? That way you have that information so that you can inform the public that there is in fact somebody there to record. And then it's subject to reasonable requirements. That means basically that if the person was setting up their recording right in front and blocking people's view, you could ask them to stand to the side or to stand to the back, but they have an absolute right to record. The public body, the chair, cannot prevent somebody from recording an open meeting. They do not have a right, however, to record an executive session. Now, the chair also has some authority to keep control of the meeting, and if there's a person who is disrupting the meeting, the chair can give them a clear warning, and then the chair can order the person to leave. And if the person does not leave the meeting, the chair can have a police officer remove that individual. And hopefully the meetings don't quite reach that level. So let's talk a little bit about meeting minutes. This is the record that the public body creates of their meeting. And every public body has to create minutes. They have to take minutes for every meeting of both open and executive sessions. Minutes must state the date, the time, the place of the meeting, and a list of the members present or absent. What I recommend here is actually listing both present and absent. In other words, list all the members and whether or not they were there. Minutes must include a summary of the discussion of each topic, and this is a new requirement under the open meeting law. Now, the open meeting law doesn't define what a summary is. It just says a summary of each topic. It doesn't need to be a verbatim transcript. It doesn't need to be what each person said, but it should be generally enough detail so that a member of the public who did not attend the meeting could read those minutes and understand what it is the public body discussed, and have a good sense of the nature of that discussion. The public body might want to include minority and majority opinions, dissenting views. It can be a few paragraphs, it can be a few sentences, depending on the discussion. The minutes must also include any decisions made, any actions taken, and a record of all votes. And secret ballots are explicitly prohibited. There can never be a secret ballot. The minutes, finally, must include a list of the documents and other exhibits used by the body at the meeting. This only is a list of the documents. The actual documents do not have to be part of the minutes. So at the very end of the minutes, there can be just a list of each document or exhibit that the public body used, or it could be listed throughout. Those documents are still going to be public records. They still have to be retained, but they just aren't part of the minutes. I do get a lot of questions about what constitutes used by the public body. It's generally something where it's been distributed to the public body, all the members of the public body have had access to it. If there's an individual in the audience and they have notes and they're addressing the public body and they're reading from their notes, those aren't used by the public body. What that person read might be reflected in the minutes, but the actual document isn't used by the body. But a presentation, a PowerPoint, for example, any report, any plan distributed to the board members, that would be used by the public body. So let me talk a little bit about executive sessions. And these are the sessions where the public body can go behind closed doors, outside of the public view, and conduct business. And there are only 10 specific purposes for executive session. And if a public body ever enters executive session, they have to do so for one of these 10 reasons, and they have to cite that reason. It's not appropriate to enter executive session because the public body believes that this should be confidential, this should be private, or it's not in the public interest. They have to lawfully cite one of the 10 reasons. So public bodies may enter executive session, but in order to do so, there are certain procedural requirements they must follow. First of all, a public body has to convene an open session prior to going into executive session. It's not appropriate to have a meeting that says 6:30 executive session, 7 o'clock open meeting. The public body has to start an open meeting and then vote to enter executive session. The chair should state publicly the purpose for the executive session, meaning they have to state one of those 10 purposes I'm going to talk about in a minute, And they have to provide as much detail as possible about the reason for that executive session without compromising the purpose for entering into the executive session. So, for example, if it's one of the exceptions you'll see is for litigation. If the reason is to discuss litigation strategy, then the public body should state that it's purpose 3 for litigation, and they should state what the litigation is, if doing so would not compromise their purpose for entering executive session, and generally it won't. You know, if the public body is engaged in litigation, the fact that they're discussing it wouldn't in itself be a problem. It's just if they sort of talked about the actual subject matter, that might be a little too much. Now, they must conduct a roll call vote to enter executive session and obtain a majority of the members voting. And it's actually a majority of the members of the body have to vote in order to enter executive session. They have to get a majority. It has to be by a roll call vote. And a roll call vote means they call each member, they call the roll, and the person says yes, no, or abstain. They also have to announce whether the open session will reconvene after the executive session. This is really important. What the public body has to do, or the chair, say whether or not they're going to actually continue with the meeting in open session, or they're just going to adjourn an executive session. And if they fail to do this, so if they go into executive session, they didn't say that they would come back into open session, and then the public body reconvenes and continues conducting business, members of the public aren't going to know. They've left the room, they may have gone home because it was an executive session, and they won't know that there's business being conducted. And so our office might nullify any action taken if that's the case, if they miss this important procedural step. Public bodies must still maintain minutes and documents of the executive session. And this is important. It's even more important to do this in executive session than open session, although it's still very important in open. But this is the only record that the public will have of what occurred in executive session. And it's important that the public will eventually know what occurred. For the most part, with some very few exceptions, anything that happens in executive session will eventually be released to the public. So it's important that the public body maintain very accurate minutes, and they retain any documents they used. This next one is extremely important for public bodies, and particularly for public body chairs to keep in mind. The public body can only discuss the matters for which the executive session is lawfully called. Like I said a moment ago, there are 10 purposes for executive session. If the public body cited one of those purposes, and let's use litigation example, and they talk about litigation, and then while in executive session they start talking about the budget, that would be appropriate for open session, and that's not appropriate for executive session. They can't stray off that topic, and it's really incumbent upon the chair to moderate that discussion, to sort of say to the board, wait a minute, this is appropriate for open session, we can't talk about this here. It's also not appropriate to talk about something else that would be appropriate for executive session if that purpose was not cited. So if you lawfully went into executive session under the litigation exception and you want to talk about a contract negotiation that's totally unrelated, that's appropriate for executive session, but not this executive session because the public body didn't cite it. And so the public has no notice that this is what they're going in executive session to talk about. So it's really, really important that the public body is very narrow in its discussion and is only talking about those matters for which the session is lawfully called. Finally, the public body must conduct roll call votes for any votes taken during executive session. It's not appropriate to sort of have a consensus or just come to a general agreement. Any decision made by the public body, there has to be a roll call vote. Every person has to say yes, no, abstain. Because again, this is the only way the public has a record and can understand what occurred during this meeting. So I'm going to talk about each of the 10 executive sessions, and I'll try to sort of give you a little detail on each one. Phil, I forgot to introduce Phil, our paralegal, Phil Mantilla. He's going to help me out here on the computer in the back, but Phil is the one who takes a lot of the phone calls and a lot of requests we get at the division. The first one is, here it is. Here's the actual text from the statute. This is to discuss the reputation, character, physical condition or mental health, rather than professional competence of an individual, or to discuss the discipline or dismissal of, or complaints or charges brought against a public officer, employee, staff member, or individual. So there's a lot going on in this purpose. This is purpose one. A couple things to note. First of all, there's a lot here that you can meet to discuss an individual, but you cannot meet to discuss an individual's professional competence. So evaluations are one of the things that a lot of public bodies do, but those are only appropriate for open session. So if the school committee is evaluating the job performance of the superintendent or the principal, that has to be done in open session. If the Board of Selectmen is evaluating, if they're conducting an annual evaluation of the town manager or the town administrator, that has to be in open session. It's only when they're discussing the mental health or some character issue, or if there's a complaint against someone, or they're meeting to dismiss or discipline an individual, that's when they can cite Purpose 1, but not for general job performance. If a public body is going to hold this executive session, there are a number of procedural steps they must follow and a number of rights they have to afford an individual. And if they fail to do any of these, then our office, if a complaint's filed, could nullify that action. So we, for example, if an employee is dismissed in this process but they weren't given some of these rights, our office could reinstate that employee. First of all, the person who's subject of a Purpose 1 executive session must be notified in writing at least 48 hours prior to the proposed executive session. So they should receive in writing 48 hours before a notice of the executive session and the specific purpose. They have the right to request that that session be open. If they request it, then the public body has to proceed in open session. The purpose of this executive session really is to protect the confidentiality of that individual and their privacy. But if they decide that they want to waive that, then it has to be in public. They have the right to be present at the executive session during deliberations which involve that individual. And they also have the right to have counsel or representative present and attending for the purpose of advising, but not for the actual purpose of active participation. However, the individual who is subject of a Purpose 1 executive session does have the right to speak on their own behalf during those deliberations. And they have the right to cause an independent record to be created by either audio recording or by a transcription service, but it's at their expense. So all of these are the rights that need to be afforded to this individual, and if the public body fails to do that, any action they take against that individual could be nullified. Purpose 2. Purpose 2 is to conduct strategy sessions in preparation for negotiations with non-union personnel, or to conduct collective bargaining sessions, which would be with the union, or contract negotiations with non-union personnel. So when negotiating a contract or collective bargaining agreement in executive session, this would be a proper purpose for a public body to go into executive session. If the public body reaches an agreement, they still have to ratify or vote on the agreement in open session, because this is only authorizing the negotiation process or the strategy process, but not the actual final product. So if the school committee is in negotiation with the superintendent, they come to terms on an agreement, they still have to go into open session to actually vote to approve that agreement, even if they came to terms in executive session. It doesn't necessarily have to be right away. They could wait a week, but then it's not a final document, it's not an agreement until they've had a vote in open session. When discussing the contract of non-union personnel, there's a presumption that professional competence of the individual has already been discussed in open session. Like I talked about under Purpose 1, professional competence is not proper, it's not appropriate for executive session. So there's a presumption that if there's a contract negotiation, that let's say if the school committee is negotiating the contract for a superintendent, that the discussion of the superintendent's professional competence and job performance, perhaps their annual evaluation, that's already been done in open session. So that then they can use that information during the contract negotiation or strategy process. Purpose 3 is to discuss strategy with respect to collective bargaining, again with the union, or litigation if an open meeting may have a detrimental effect on the bargaining or litigating position of the public body and the chair so declares. So the chair has to declare, they have to make a statement at the very beginning of the meeting in open session that deliberating during an open session would have a detrimental effect on their position, on their litigating position or their bargaining position. If the public body is going to enter executive session under this purpose, and specifically for litigation, that litigation has to be pending or imminently threatened. So the public body has to actually be engaged in a lawsuit, or they have to have some real notice that they're about to be sued or they're about to enter litigation, and they need to discuss strategy. It wouldn't be appropriate if it's like, for example, a zoning board. They know that somebody could appeal their decision in court. That's not an appropriate reason to enter executive session to make their final determination. But if someone's really made active steps to bring a suit, that might be an imminently threatened litigation. Purpose 4 is pretty straightforward, and I've just summarized it here. It has to do with the deployment of security devices or security personnel. The public body can enter executive session because they don't necessarily want to inform the public where their security devices or where the security personnel are going to be deployed for a certain instance. And number 5 has to do with criminal misconduct. If the public body is investigating criminal misconduct or looking to refer a matter to the district attorney or to the authorities, they have the right to enter executive session to discuss that, but the individual who is subject to their investigation does not have the right of notice like the individual in Purpose 1 has. Executive session Purpose 6 is to consider the purchase, exchange, lease, or value of real property of land if the chair declares that an open meeting may have a detrimental effect on the negotiating position of the public body. So this has to be to consider the purchase, sale, lease of land. And the chair has to declare that deliberating during an open session would have a detrimental effect on the negotiating position. There's a couple of these where the chair has to make this statement in public prior to entering. And it is to protect the negotiating position. So it's generally where there's a specific property that the board is interested in, that they're going to negotiate, they have a negotiating position. It's not really acceptable to use this purpose more broadly to sort of have all kinds of discussions about development of a property if they don't have an actual negotiating position to discuss. Purpose 7 is a little bit of a catch-all. And what it says is it says to comply with or act under the authority of any general or special law or federal grant-made requirements. Now, what this means is that if there is a law that requires confidentiality, it requires that a decision be considered behind closed doors or be considered outside of the public view, then the public body can cite Purpose 7, but they have to cite that law. And it has to be a state law or a federal grant-made requirement. So they can't cite a rule or regulation or a bylaw or an order. It certainly couldn't be the rules of that public body. It has to come from Massachusetts state law or a federal grant-made requirement. But if, for example, the public body wishes to discuss a certain document and that document is protected under the Public Records Law, they could cite Purpose 7, cite the Public Records Law, and enter executive session to have that discussion. It's limited. They have to have, there has to be a real purpose. The statute has to require confidentiality, and they have to be very clear when entering executive session that they're doing so under Purpose 7 and that they have to cite the statute. It would never be appropriate to simply cite Purpose 7 and not cite the statute or other requirement that would allow them to go into executive session. Purpose 8 is to consider or interview applicants for employment or appointment by preliminary screening committee if the chair declares that an open meeting will have a detrimental effect in obtaining qualified applicants, provided, however, that this clause shall not apply to any meeting, including meetings of a preliminary screening committee, to consider and interview applicants who have passed a prior preliminary screening. So let me try to break this one down a little bit. It's kind of long, it's kind of difficult to get through. Public bodies can create preliminary screening committees when hiring. So a school committee may be hiring a new principal. That school committee can set up a preliminary screening committee to interview candidates. And that screening committee can enter executive session to screen candidates. The full committee cannot, but the screening committee can. The preliminary screening committee must consist of a sub-quorum of the body, though it may include people who are not members. So, sub-quorum means fewer than the majority, generally. So let's say there's a 7-member school committee. They could create a preliminary screening committee that includes up to 3 members of the school committee, as well as teachers, parents, members of the community, to interview applicants. And that committee can meet in executive session. However, they can only interview or screen candidates during a preliminary screening process. They can only do that in executive session. And once there are finalists, all screenings must be conducted in open session. So if this screening committee starts with 50 applicants and they narrow it down to 5 finalist candidates, any further interviews, any further screening process has to be done in open session, either by the screening committee or by the full committee. And the chair, like with some of the other ones, the chair has to declare that an open meeting would have a detrimental effect in obtaining qualified applicants. So the chair has to state this in open session before the screening committee goes into executive session. with a mediator on litigation or some other decision. So if there's a mediation process that the board is engaged in, they can enter executive session and confer with the mediator to discuss their position. Purpose 10 has to do with trade secrets in the course of activities conducted by a public body as an energy supplier. So there are a few distinct public bodies that are actually energy suppliers. That is what they do. This is inappropriate for example, if the school committee, since the school has an electric bill, they're not really an energy supplier. This is really public bodies that are in fact, their function is to supply energy. And then where there are certain trade secrets in the course of activities, they can enter executive session. Generally, this one doesn't come up too much. I want to talk a little bit about the minutes and the records and the other documents that a public body uses during the meeting, and sort of what happens to those documents and what the public body's responsibilities are. Now, for executive session minutes, those minutes must be disclosed. Once publication will no longer defeat the purpose for having entered executive session, unless an exemption under the public record law applies. So, let's say the public body went into executive session and discussed litigation strategy, and then 2 months later, that litigation settles. Once that litigation is settled, there's no longer, and it's final, there's no longer a reason to keep the minutes confidential. The purpose for executive session has expired, and the public body has to release them. Now, a new requirement under the open meeting law is that the minutes must be reviewed periodically by the chair or the public body to determine if the purpose for executive session remains. And that determination must be announced during the next meeting and be included in the minutes. So, reviewed periodically, it's not really defined, but there really should be an active, the public body should be active in reviewing executive session minutes. It's not appropriate for executive session minutes to remain confidential and unreviewed for 6 months or a year, certainly every few months, but the public body should pay attention to when those purposes expire. If it's litigation, if it's a contract negotiation, once that contract has been finalized, once the collective bargaining agreement has been accepted, when those purposes expire, the public body has a requirement, they have a duty to review those minutes and release them to the public. Minutes must be provided within 10 days, and we're talking about executive session minutes, in response to a request, unless a review has not yet been undertaken, in which case the minutes must be reviewed by the board at its next meeting, or within 30 days, whichever comes first. So essentially, if somebody requests in writing the executive session minutes and the board hasn't yet released them, then within 30 days they have to review those minutes and make a determination whether the purpose still exists or that purpose has expired. And they can respond by saying, well, the litigation's ongoing, the purpose still exists, we can't disclose these. Or they have to say, well, the purpose has expired and we are going to publicly release these minutes. So, meeting minutes have to be created and approved in a timely manner for both open and executive sessions. And documents and exhibits used by the body must be retained by the public body, but they don't need to be physically stored with the meeting minutes, as I described before. There needs to be a list of each of the documents used by the public body, but it doesn't have to be part of the minutes. The documents themselves, however, those are records, and those are public records. Minutes of an open session must be provided upon request within 10 days, whether in draft or final form. So, if a public body holds a meeting, and somebody that day requests the minutes in writing, then those have to be provided in 10 days, in whatever form they are. Even if they're in shorthand, they haven't been typed up, they haven't been approved by the body, doesn't matter. Whatever record there is has to be provided within 10 days of request. Executive session records, like the minutes, must be disclosed once publication will no longer defeat the purpose for having entered into executive session, unless exempt from disclosure. So the records really have to be reviewed and are really treated a lot like the minutes. Finally, the Secretary of State recently updated the Municipal Records retention schedule. A lot of the records that a public body uses, most of them are going to be public records. Public records is actually not something that our office enforces. We don't enforce the public record law. We don't advise on public records. It's actually handled by the Secretary of State's office. The Secretary of State recently updated their municipal retention schedule, which includes every type of document a board at the municipal level would look at, and it tells you how you have to retain it, for how many years, when you can destroy it, things like that. And they've updated it along with the new updates to the open meeting law, so I definitely recommend those of you who serve on local public bodies, to make sure you've reviewed that, and you've looked over what are the types of documents that you usually use and the things that are relevant to your public body, and to be aware of those rules. There are a few types of documents that are exempt from public disclosure by statute, by the open meeting law, and these are new in this law. So the following materials are exempt from public disclosure. Materials used in a performance evaluation of an individual bearing on his or her professional competence that were not created by members of the body for the purposes of evaluation. Now, once again, I apologize for these kind of legalese definitions, but this is pretty much pulled right from the statute. Let me try to explain what they're saying here. Performance evaluations, like we said earlier, are not appropriate for executive session. There are, however, some public records conflicts here, in that in certain evaluations are considered part of a personnel record, which is protected under the Public Records Law and it's confidential. What this exemption is stating is that when, let's say, a school committee is conducting an evaluation of a superintendent, the evaluations created by the members of the school committee, the actual forms that they fill out, those have to be public. Those are not exempt from disclosure. Anything created by a member of the public body is public. However, other people who participate in the evaluation process, for example, if teachers or parents were to fill out evaluations of that superintendent, those would be exempt from disclosure. Those are confidential. Those are part of the personnel record. So the law draws a distinction between what members of the public body create in an evaluation process, and what people who are not members of the public body create. So, also exempt from public disclosure are materials used in deliberations about employment or appointment of individuals, including applications and supporting materials, but excluding resumes, which must be disclosed. So when the school committee is reviewing applicants for candidates for principal, they're reviewing the finalists, all those application materials, those are exempt from disclosure, but resumes have to be provided. Those are public documents. So the last topic I want to cover is the complaint process. Hopefully by this point you have a good sense of what the requirements of the open meeting law, what those requirements are. You understand who's subject to the open meeting law, that the public body has to take minutes, that they're only there to post notice, and there are only 10 purposes for executive session that the public body can lawfully go behind closed doors for, and that they have to follow certain procedures when entering executive session. Now, if a member of the public or a member of the public body or a member of the media believes that there was a violation of the open meeting law, there's a complaint process they can follow that will initiate our investigation. The first step is that the complaint has to be filed in writing with the public body within 30 days of the alleged violation, or if it could not reasonably have been known at the time, within 30 days of the date, the complainant reasonably should have discovered the alleged violation. And when I say that it has to be filed in writing, it has to actually be filed on a specific complaint form that's available at the Attorney General's website. It's often available with municipal clerks. And that complaint form is very simple, 2-page form where the public body fills out their, rather the complaining party fills out their information and their reasons for filing the complaint. So there's this 30-day requirement we call the discovery rule, where a member of the public who's filing this complaint, they have to file it within 30 days of reasonable discovery. So, if a public body holds an open session, and during that open session there's a violation, whether or not that person was there, within 30 days they have to file the complaint, or it may be untimely, because anyone could reasonably have discovered that conduct that was done publicly. If the school committee, for example, were to violate the open meeting law in executive session, and then 5 months later or 6 months later they release those executive session minutes, and that's when one could reasonably discover the violation, it's within 30 days of the release of those minutes. So it's a 30-day discovery. The complainant has to file in writing with the public body, and then the chair of the public body has to accept that, that complaint and disseminate it to all the members of the public body. So the complainant has to file it with the chair of the public body, and we also require that they submit a copy when they're filing with the local public body, a copy with the municipal clerk, so that the town is also put on notice that there's a complaint been filed. So the chair, once they receive the complaint, they disseminate it to the members of the public body. It's not appropriate for a chair to simply write a response, or for the chair to hand it off to town council or town manager and ask them to deal with it. it has to go to the other members of the public body for review. The public body then has 14 business days in which to respond and inform the Division of Open Government of any remedial action taken. Now, so the public body has received the complaint, it's been disseminated. They can decide to discuss it, or they can vote to have the town attorney answer it, or to have just the chair answer it. That's fine. There has to have been some decision taken by the public body. Within 14 business days, which is generally 20 actual days, they have to send their response to the Division of Open Government and a copy of that response to the complainant. The public body may request from the director of the Division of Open Government an extension of time to respond for good cause. If there's a reason the public body can't meet or they need more time to investigate the complaint, they can request from our office, and we'll generally grant it if there's good cause, some extension in which to respond. So the complainant believes there's a violation. It's within 30 days, reasonable discovery, and they filed it with the public body. The public body chair has disseminated it to the members. The members have agreed on a response, and they've issued that response back to the division and to the complainant. That person then reads the response, and they can decide if they're not satisfied with the resolution of the complaint by the public body. That person then may file the complaint with the Division of Open Government 30 days after the complaint is filed with the public body. So there's this 30-day requirement now where the person filing the complaint has to wait 30 days from the day they first filed it with the public body before they can file it with our office. And the reason this was put in the statute, I suspect, was because they do want to encourage members of the public and the public body to sort of try to come to some resolution, to just come up with some remedial action before the Attorney General initiates the investigation. So there's sort of a 30-day waiting period in hopes that it may be resolved at the local level. But if it's not resolved, then the complainant is not satisfied that the public body really addressed the complaint, they can file with our office. To be considered timely, complaints must be filed with the Attorney General within 90 days of the date of the original alleged violation. So once they've received the response from the public body, they can't sit on it for 5 or 6 months and then decide to file with our office. It really has to be within a pretty short time frame. So once that individual has decided that the public body's response is not acceptable, doesn't resolve their complaint, they file with our office, and our office will send out an acknowledgement to the parties. And then we may request documentation, we may request interviews. We're going to initiate an investigation if we believe there's any merit to the allegations. So we may ask for executive session minutes, which we're going to review. We may want to talk to members of the board to ask what occurred. And ultimately, we're going to make a determination whether or not there's been a violation of the open meeting law. We're also going to make a determination of whether or not there was an intentional violation of the open meeting law, and I'll talk about in a minute why that's important. Then we're going to look at whether any action taken by the public body was adequate. It may be that the person sent the complaint, the public body said, you know, you're right, this was actually a violation of the open meeting law, and here are all the steps we took to remedy that, to correct it. So we're going to look at what action the public body took. And finally, we're going to issue a resolution. Generally, it's going to be a formal resolution. It's going to be a letter. It'll be a determination letter that will describe the nature of the allegations, our findings. We'll recite the facts, we'll recite the law, and we'll come to some conclusion. And if we find there's a violation of the open meeting law, we're going to issue an order. The last step here is that the public body has a right of appeal by statute. So if we find that the open meeting law was violated by this particular public body, and we order them to take certain remedial action, they can go to court and appeal it. There's also an alternative complaint process, and this existed under the old open meeting law. This isn't new. The Attorney General or 3 or more registered voters may initiate a civil action to enforce the open meeting law. For a state public body, the 3 registered voters must file in Suffolk Superior Court. For all other public bodies, they must file at the Superior Court in any county which the public body acts or meets. So if they initiate this alternative process, then they're not going to come through, they're not filing a complaint to the public body, they're not requesting the Attorney General's review, they're just going right to court. Generally, if a complainant, 3 registered voters choose this process, the Attorney General is not involved. Now, there are a number of remedies under the open meeting law that are available to the Attorney General to order in order to resolve an open meeting law complaint. First of all, we can compel immediate and future compliance with the open meeting law. This is generally a warning. This is saying that we found you in violation, and we're ordering you to comply with the law. And any further violations of the law, and particularly of this nature, we may consider that an intent to violate the open meeting law. So it's a pretty strict warning. We also can compel attendance at a training. So we can remedy a public body by ordering them to attend one of these trainings that you all just sat through. We also can nullify any action taken in violation of the open meeting law, which is a pretty serious step, and it's something that was not available to the district attorneys under the old open meeting law, but it's available now to the Attorney General. And I skipped one, but we can compel the public release of minutes or other materials. So if there's a complaint that the public body met in executive session, and that session, the purpose for that executive session is now expired, and that person is requesting to see those minutes, and the public body says, well, we feel that the purpose has not expired, we may review that, and we may determine that the purpose has expired, and we may order the release of documents, of minutes that are being withheld. We have the power to reinstate an employee and make whole. So, for example, as I talked about with Purpose 1, if we find that the public body did not follow the proper procedures, did not give somebody notice that they were going to be discussed under a Purpose 1 executive session for their dismissal, we may reinstate them, we may make them whole. We can also impose a civil penalty of up to $1,000 on a public body for each intentional violation. So this is where the finding of intent becomes important. If we believe it was an intentional violation of the open meeting law, for each violation, we can fine $1,000. However, it is a fine of the public body and not of the individual members. The individual members are not liable by themselves, but it's the public body that has to pay. So it generally would come out of the taxpayers' funds. We also can issue order any other appropriate relief, and sort of that depends on the situation. Finally, in wrapping up, we want to draw your attention to some resources that are available. The Open Meeting Law website is really the best resource to start. Anytime you have a question about the Open Meeting Law or trying to learn more, the Open Meeting Law itself is available there, our regulations are there. We also have frequently asked questions that we update constantly. We're really trying to get as much information as we can from members of the public. As we get the same questions over and over, we try to provide answers on the website. So do look at the frequently asked questions section. We also have an Open Meeting Law guide, which if you're a member of a public body, this should have been distributed to you once you take office, because this is part of what you have to certify you've reviewed within 2 weeks. We also put up on our website now every determination that we issue. I think we've now issued something more than 30 or 40 determinations for violations of the Open Meeting Law. And so if you really want more in-depth understanding of the Open Meeting Law, you can actually review the determinations we've already made since the law has been within our jurisdiction on July 1st of last year. And finally, this is the contact information. If you have questions, we always want to try to provide answers. We want to try to help people avoid violations. Like I said at the beginning, we can't answer questions about something that may have occurred that could be subject to our enforcement. But if you ever have a question, you can email us at this address, or you can call us at 617-963-2540. We try to get back to people within 24 hours if we don't even pick up the phone right there. We are a little short-staffed for the summer, but we do try to get back to everybody and do as much as we can to be a resource and to help members of public bodies. We're really trying, we're really not trying to hover over public bodies to sort of come down with the hammer. Really, this is about openness. This is about facilitating transparency. We really want to be a resource to help you do that, to make your lives easier as members of the public body or as members of the public in participating in government. So at this point, if you have questions, I'm not doing the hands yet, we distributed some index cards at the beginning, and if you didn't get any, there's probably still some up in the front table when you came in. And so we'll take a short 5-minute break. I'm going to review all these index cards. Phil's coming around to collect them. And I'll come back and review all those questions and try to provide as many answers as I can. I'm going to try really hard to get us out of here before they drop the puck for the Bruins game. So why don't we take a 5-minute break, and then we'll come right back. Thank you. I appreciate everybody who stuck around. Hopefully you'll get some more detail here. All right, the first question has to do with a change of meeting status. It says that the hearing meeting regulations have not been met prior to a meeting. Can that hearing status change to a public meeting if the requirements as such have been met? So I think what they're saying here is that the public body intends to hold a public hearing, which is a little different than an open meeting. And they weren't able to meet the requirements for notice for that hearing. Sometimes a hearing might require, under a separate statute, 2 weeks notice in a newspaper. So yes, the answer is essentially as long as a public body posts notice 48 hours subject to a meeting law, they can still have a meeting. They may not have met the hearing requirements. They may not be able to hold a legal public hearing. But as long as they posted their meeting notice under the open meeting law, they can have an open meeting. In fact, when they're holding a hearing, if it's a meeting of a public body, even though they're holding a hearing, they're still required to post their open meeting notice. Even though they've done the 2 weeks notice in the newspaper and notified abutters. Anytime there is a deliberation and there's a quorum, a public body has to post a meeting notice subject to the open meeting law. Do executive session minutes need to be approved in an executive session? Very good question. They don't need to be approved in executive session, but certainly a public body can enter executive session to review and approve executive session minutes and discuss their release. The best method for doing that is to generally go back into executive session under the purpose they first entered, and to state that they're going in to discuss the release or approval of minutes. So if the public body had first entered executive session to discuss litigation, and that litigation expired, and the public body wants to then meet to determine whether or not to release the minutes, or rather that litigation settled, so the purpose is expired, they can then go into executive session under the same purpose and say to discuss, release the minutes from discussions related to this litigation under purpose 3. So whatever the purpose is they first went into, because it would be difficult to have that discussion in open if you're talking about whether or not this is still confidential. And often, if it's a substantial conversation, that they may be taking minutes during that, and then they would, one of the things they can do is vote to release those minutes as well, upon conclusion of that discussion. One quick note that I kind of glossed over, there is a difference between approval and release. Minutes have to be approved in a timely manner. So for an executive session, the board still needs to approve those minutes in a timely manner. A timely manner may be the next meeting, the next time they go into executive session, generally not more than a month or 2. But they may approve those minutes, but not yet release them. They still may remain confidential. A purpose may still exist for executive session. It may be several months before the purpose expires. So even though those are approved minutes, in other words, the body has voted those are the accurate minutes of this executive session, but they may decide later whether or not to release them to the public. And there is no requirement, by the way, that minutes be published, just that they're released, that they're public, that they're made available upon request. We certainly recommend that when minutes are released, whether they're open session minutes, whether they're executive session minutes, it's always a good idea to publish them to a website, but it's not required under the law. The next question is, what is the exact process for releasing executive session minutes? Essentially, just talk about it. They can meet in executive session, they can meet in open session, and they just have to vote whether or not to release it. Sometimes some public bodies will actually authorize, they'll just vote to authorize the city solicitor or the town council to review the minutes and make that decision independently. Can staff forward a request for an agenda item to other members of a board? So, couple things in this question that sort of brings up. First of all, any staff member can always communicate with a quorum of the board, and that's okay, so long as they're not facilitating a deliberation. The only thing that's a deliberation is a communication between or among the quorum of a board. So if you have a staff member, if you have a secretary of the Board of Selectmen, and that secretary can email the quorum members with information, with updates, with requests for agenda items. They receive agenda requests, they can forward that to the chair. The person just cannot act as a facilitator of deliberation. One thing that you want to be aware of is a serial communication. I kind of skipped this at the deliberation slide. But if you have a situation where you have a 5-member board, so 3 is a quorum, and A calls B, and B then calls C and says, I just spoke to A, and here's what A thinks, here's what I think. You now have 3 people who have communicated, you now have a quorum, and that's a serial communication, it's a deliberation that's in violation of the open meeting law. And so it's really important for board members to be aware of this and to really not communicate in that fashion, and it's important for staff members to not facilitate discussions between a quorum. If a staff member is talking to all the board members and telling them what each other thinks, even though they don't talk directly to each other, it's eventually violating the open meeting law, and it's getting around the requirements of the open meeting law. So a staff member can forward a request for an agenda item to other board members, but they have to be careful not to facilitate deliberation. Are visitors to a school committee meeting required to sign in? Well, no visitor to any meeting is required to sign in under the open meeting law. Whether the school committee sets up that requirement, that's up to them. The open meeting law is silent on that. There are no requirements to sign in. Do town meeting minutes require inclusion of discussions? I don't know the answer to that. Town meeting has a separate statute, separate requirements for recording the meeting, for notice. It's a totally different statute that we don't oversee. I suspect there are probably some requirements there, but I don't know offhand what they are. So that's something where you might want to take a look at the actual law. When re-elected or reappointed to a public body, does the individual need to recertify regarding the open meeting law requirements? The answer is yes. Upon reappointment or re-election, within 2 weeks of that reappointment or re-election, the member of the public body needs to fill out a certification form that they've, again, reviewed the open meeting law, they're up to date. All right, so good questions so far. Can public bodies hold meetings on Saturday or Sunday properly posted? The answer is yes. The open meeting law doesn't address this. There's no restriction against Saturday, holiday. There are a couple boards that by law can't meet during an election. I don't know off the top of my head what they are, but that's something to be aware of. But generally, there's no prohibitions there. But we encourage public body members to meet at times that are most convenient for members of the public. Regional Public Housing Authority, is it okay to post the notice to our website? The answer is yes. If that regional body, the Housing Authority, has decided to pursue an alternative method for notice posting, they've picked a website, hopefully their website, they've notified our office, then they can post to their website rather than posting to each of the clerks of the 27 communities that this Regional Housing Authority may oversee. Is it appropriate to post to the Council of Governments website? It's whatever website they've chosen and they've notified us. Generally, it's a good idea that if the Housing Authority has its own website, that's where they're having the notice postings. They shouldn't be hidden, they should be hard for members of the public to find them. But if there are public bodies that are small, that don't have their own websites, so that maybe the parent agency or maybe an affiliated body or maybe a town where they're actually posting their meeting notices. But it has to be on record with our office if they're following that alternative notice posting method. Is a collective bargaining negotiating team, which includes a member of the board or school committee, a public body subject to the open meeting law, and do they have to post notice and take minutes? I think the answer to that generally is yes. That may be something where I need to look a little specifically at the statute, but I know there are statutes which require negotiating teams, and they maybe involve members of public bodies, administrators, but they're required by statute. Generally, any multiple member body created by statute is subject to the open meeting law. So I believe the answer there is yes. Any unfunded mandate claims, and if so, what has been the auditor's response? I believe somebody filed a claim essentially saying the open meeting law is an unfunded mandate, which would have prompted the auditor's review, and that the auditor made a finding that it was not an unfunded mandate. I can't really speak beyond that because it's sort of not something our office handles, but just from my kind of paying attention, I think that is what happened. There's also a question of what happened to the exemption allowing cable advisory committees to be able to go into executive session for negotiations. I don't know. As far as I'm aware, that is not a public body, or that is not an executive session purpose. Whether there's a statute that allows a cable advisory commission to meet an executive session, that could be, and then the public body would have to file, would have to cite Purpose 7, but it's not in the open meeting law. How does a committee go out of existence, or going out of existence, prove their last meetings or executive session? That's a good question. That happens. There may be the Board of Selectmen sets up a sort of temporary committee or an ad hoc committee, and then eventually that gets dissolved, but some of the minutes may not have been approved. We generally look to the parent body, whatever entity created that public body, to approve those minutes and to take care of that. But it sort of depends on what the specifics are. Meeting minutes. Secret ballots are expressly prohibited. Please clarify. Do minutes have to contain who moved and who seconded the motion? Well, the answer is no. It doesn't require that. Certainly, a lot of public bodies add that in. It requires any action taken, any votes. I'm not sure it specifically says that you have to list who moved the motion, but certainly you have to record the vote. We found no reference to that, so we've been telling our volunteer minute takers that they don't have to record it. So they do have to record split votes by name. So if a 5-0 vote can just say unanimous, but 3-2 say which members. Let's see. In referring to open sessions, not executive sessions, but either way, we do not need to record who made the motion and who seconded it. That's right. If it's the executive session, we need to say, even if a 5-0 vote, as the members. So it's a good idea. I mean, if it's unanimous and the public body recorded who's at the meeting, you probably can say unanimous, but the strict law requires roll call vote and list it as a roll call. It's the Academy Awards not being played off here. All right, I have just a couple more. There's a suggestion here to please add school councils, which are the body of teachers and families from each public school has since ed reform. As an example of a public body that is a local public body subject to the open meeting law. That is correct. School councils are created by statute. Those are local public bodies. Please clarify that members of a public body can in fact provide to other members of the public body a report that is the embodiment of that member's opinion, such as so-and-so, view of Article 25 preparation for a select board agenda item, which was emailed as an email report, which the person wants fellow members to understand before they show up in May 2nd select board meeting. So is it okay to do that so long as you don't say, please support this? Generally, yes. I mean, this gets a little, you gotta be a little careful not to facilitate a deliberation, but any document that a member of the public body wants to distribute for consideration at an upcoming meeting, they can do that. It's okay if that report may contain some opinions. What they shouldn't do is initiate any discussion on that report. They shouldn't say, here's my report, I hope you all approve it, here's my report, please tell me what you think over email. That's not appropriate. Certainly, there are documents that are going to have some opinions. They can distribute it, or they can send it to the chair, and the chair can send it as part of the packet that goes to all the board members ahead of the meeting. So long as there's no deliberation, discussion that follows, it's okay if it's a report that has opinions. If a DPW, Department of Public Works Director, creates a subcommittee to obtain information for him, and that subcommittee contains selectmen, is that, I guess, okay under the open meeting law? Or rather, is it subject to the open meeting law? This is somewhat fact specific. It's hard to answer a question like that. Like I talked about with the Connolly exception, a specific public official can create a committee to advise that public official on something they have sole authority over. If they're sort of creating a committee to help them gather information or develop general policy, that's something they don't necessarily have sole authority to do, that may be a public body subject to the open meeting law. So it really depends on what the function of that committee is and what its purpose is, how it's being conducted, how it was created. Because it may be that the Department of Public Works director, certainly it's in their job description to collect this information, but there is nothing that they have specific decision-making power over. So this is one of those it depends answers. And this is a very difficult question that our office spends a lot of time working on, is trying to help guide towns and municipalities about what is and isn't a public body. Because it is a very broad definition, and we're trying to continue to develop guidance on that. Mass General Law Chapter 32B created an insurance advisory committee for the cities and towns. They provide advice to the municipality on health insurance for employees. Is this a public body? I have to look at that statute to be able to answer that. I think the answer is yes. But if somebody wants to follow up with me, I'm happy to talk further. I have looked at the statute, and I just can't remember what our decision was that. But that we'd have to look at the statute, how this body is created. It's created under state law, how it functions, whether it's really multiple member board established to serve a public purpose. So I don't want to give a final answer on that until I have a chance to look at that a little further. Could you go over specifically how you handle a performance review in open session? is the employee there, and the committee is trying to compile information, discuss performance. I'm not sure I can tell you the best way to do it, just that it has to be done in open session. So the members of the public body could meet with the person who's being evaluated. They could do it without the person being evaluated, although if it's an open meeting, they have a right to be there. It can be sort of an interview process. They could have had filled out evaluations and be reviewing information that other people have filled out. There's really, the open meeting law doesn't address that. It just says that discussions of professional competence have to be done in open session. So that's the kind of thing where you would want to talk to your town council or the school committee chair or the people who have done it in the past and sort of understand a little bit about the best practices. If a public hearing is continued to a date certain, does there have to be a new notice posted? And do interested parties have to be notified again, i.e. abutters for a zoning matter, notice republished in a newspaper? We don't oversee this law. Public hearings is a different law, so I don't want to opine on that. Certainly if it's continued, you would have to file a new open meeting notice for the hearing. But I don't know what the rule is on public hearings, so that's just not something our office has jurisdiction over. Is there any requirement for the clerk to maintain minutes of various public bodies, or is it up to the individual bodies to maintain copies of all their minutes? It's up to the individual bodies. The public body is ultimately responsible for creating and maintaining and retaining the minutes of their meetings and documents. However, a lot of public bodies work with the clerks, and with the clerk's consent, designate the clerk as the sort of holder of public records, or what's called the custodian of public records. And so certainly with the clerk's consent, and a lot of towns do this, the clerk can hold all the minutes, can hold the documents, they can sort of be in charge of keeping them, particularly because members of boards rotate, and you certainly don't want these in somebody's basement. They're probably better in City Hall or Town Hall. But the legal requirement is it's the public body's responsibility. Is it allowable, meaning not subject to the open meeting law, for a working group of a few committee members to meet to generate ideas, to sift through materials, and bring recommendations to a full board for discussion and approval? Well, that depends. Another one of my depends answers. If this committee decides, if the full parent body decides to create a working group, it's likely going to be, if it's more than one person, a subcommittee. It's going to be a multiple member board established to advise that committee. It's a subcommittee. It's subject to open meeting law. If you have a subquorum, so if you have a 7-member board and 2 or 3 members, meaning those who are not a quorum, decide to call each other up and on their own want to create a group, want to collect information, and then bring a proposal to the board, they're not doing that at the request of the full body. They're not doing that with the sort of approval. They're not being directed by the full body. So it's just a subquorum, and that's not subject to open meeting law. So the distinction there is when the actual parent body is creating a committee, is creating a working group, is authorizing these 3 individuals to work on something, that's going to be a subcommittee. If they're doing it on their own outside of the meeting, and they're not reaching a quorum, then that's fine. It's not subject to the open meeting law. So I hope that distinction is clear. Would executive sessions need to be on the agenda posted 48 hours ahead of the meeting so that the public body can't go into executive session unless it was already posted? Generally, yes. Executive session is like any other topic. If it's anticipated 48 hours before a meeting, it has to be listed in the meeting notice with as much detail and specificity as possible so as to give members of the public an understanding of what the committee will discuss, but without compromising the purpose for that executive session. If it's unanticipated, it comes up at the meeting, it's not technically a violation if the public body goes into executive session for an unanticipated topic. They certainly have to announce it at the meeting, but our office strongly encourages public bodies to postpone that until it can be added to the meeting notice unless it's either it's an emergency or something that requires some real immediate action that night. Do screening committees have to post 48-hour notice of their screening sessions? Yes, a screening committee is still a public body. It just has its own executive session purpose, but it's still a public body. It still has to follow all the rules for executive session, for meeting notice. It has to convene an open session, and then it has to vote by roll call to go into executive session. Just because it's a screening committee doesn't mean it has to go into executive session. Executive session is never required for any public body. It's always at the option of the public body. All right, and then there was one that I don't think I had a chance to read, but I'll give this a shot. is a public hearing held by a public body, a public meeting? The answer is yes. So any meeting any meeting between a quorum has to be posted. It is a meeting under the open meeting law. So the public body still needs to post notice, even if they've followed the hearing requirements and they've posted notice in newspaper and they've given notice to abutters, they still have to file the open meeting law. I guess this is saying, I think this is asking, is it okay to ask why a recording? I guess so. If that's what the question is saying, can the chair maybe ask why something's being recorded? They can. It's not, I mean, the open meeting law doesn't address that. Public participation scripts, are they public records? Not sure what scripts mean. I mean, if it's the personal notes, generally that's a question for the Secretary of State's office. You know, our office doesn't determine what is and isn't a public record. It's this Secretary of State's Public Records Division. So whether or not certain things used by individuals who are members of public bodies or public records, that's better addressed to them. I can kind of speak to the ones that are very specifically laid out in the open meeting law, where it says that all documents used by a public body, so used by all the members, those are public records. Suspension or rules, that's not in the presentation. It's not because it's not in the open meeting law. There's nothing about rules in the open meeting law. If a public body decides to adopt Robert Rules of Order or other types of rules or other systems to govern their procedures, they can do that, but it's not addressed by the open meeting law. If they fail to follow those rules, they fail to follow their own bylaws, those are not violations of the open meeting law. They may be violations of other things, but they're not violations of the open meeting law, and that generally will have to be handled at the municipal level. So on the complaint process, you said that the council president cannot merely huddle with the city attorney and respond. That's generally right. So if a complaint is filed and the chair of the public body receives the complaint, they can't simply meet with the city attorney and respond. They have to disseminate that to the public body, and the public body has to decide what action to take. The public body can review it, the complaint, and then say, well, we're going to ask the chair and the city attorney to respond. That's fine because they voted to do that. Then the chair and the city attorney can huddle together and draft a response. But it first has to be disseminated and reviewed by the public body. So the public body could have an entire meeting dedicated to responding to this complaint, or they could look at it as an agenda item, vote on having the town administrator, the city attorney, or the chair respond. That's up to them. So those were all the questions I think I had. If there's any more, I'm happy to take it. Do I just speak it out, or?
Oh, I guess you can. Can you elaborate a little bit more on continuation of meetings into the next day? You have to repost 48 hours notice?
Yep. You do have to repost. You can't continue a meeting into the next day. Once a meeting is adjourned for the day, there has to be a new notice posting with 48 hours. So you can't have a Monday meeting, it's going late, and then say, we're going to reconvene tomorrow night, same time. Can't do that. You can. In anticipation of a meeting that will run late, you can post notice for 2 nights. So you can post notice for a Monday and a Tuesday, and saying, you know, if Tuesday may be necessary, if Monday runs late, and you provide 48 hours notice for that, then the public is on notice, and you may cancel that meeting on Tuesday if you finished everything on Monday. So that's appropriate where you anticipate it, but sometimes if things run late, it's not anticipated, you still have to post 48 hours. Yes?
Does review mean publicly review? The question before, you said the council president, for instance, cannot huddle with the city attorney, right, and then they have to, the board has to review.
Right.
Should they get together at the tavern?
So the board, well, no, anytime, right, anytime a quorum of any public body is communicating, it has to be done in a meeting. So if somebody files a complaint, it has to be reviewed by the board. It doesn't necessarily have to be reviewed at the meeting. What I mean by that is, the chair could email it to all the board and say, here's something to review for an upcoming meeting. And then at the meeting, they can discuss and vote, you know, how to proceed.
So they
well, the action they take has to be, well, not necessarily. It has to be at a meeting. They could go into executive session under Purpose 1 because it's a complaint against the public body. It's a complaint against public officials, and under Purpose 1, the public body can enter executive session to review a complaint. They would still have to post a notice saying they're doing that for Purpose 1 to review an open meeting law complaint. They couldn't hide what they're doing, but they could have the discussion in executive session. For example, if it was a discussion that what they did violate in executive session previously violated the open meeting law, they may have to go into executive session to sort of discuss whether or not what they did needs to remain confidential or not. So there are reasons why they may want to go into executive session. Generally, it's a good idea to do it in the public. This is about government transparency, and the public bodies tend not to do themselves a lot of favors by reviewing open meeting law complaints in executive session, but they have the right to do it because it's a complaint against public officials, assuming they follow all those procedures. Other questions? In the back.
This is just a very nitty-gritty kind of practical question. Live in a small town, everybody is a volunteer. Take the minutes handwritten during the meeting, take them home, and then they may or may not be written up until the next meeting. So the record is in an individual's home. There's discussion about, say, if they get typed up, does one release them immediately to the public before they're reviewed by the body? Sometimes the body will say, oh, what if you make a big mistake? We'd rather review them and approve them before you make them public.
Right. So the public body is required to take minutes, and they may have a secretary who handwrites them and then wants to type them up, and they may bring them home and do that. If the public body receives a request in writing for those minutes, they have to provide them in 10 days, whether or not they've approved and reviewed those minutes, whether in draft or final form. So if they get that request, the body could hold a meeting within 48 hours notice just to discuss the minutes and review a final draft. And then they can give the final draft. If they want to wait till the next meeting, they'd have to provide the minutes in whatever form, but then they can, at the next meeting, they can approve them. And the final minutes that they approve may be different than the ones they gave in response to a records request. But the final minutes are the minutes that the body approves, that they say these are the accurate minutes that reflect the meeting. And they should do that generally at the next meeting. Does that address what you were asking?
Yeah.
Yes?
And that record and that minutes meeting, the minutes request must be in writing and
Under the law, the request for minutes has to be in writing, and that's generally the rule for any public records request. I mean, certainly if somebody asks for the minutes, it's a good idea to give it to them if it's an open session, but they're required to submit that in writing. And minutes, by the way, have to be kept in writing. You can't have just a recording to be the minutes. You can record a session and then later write the minutes based on that recording. That's fine, but the final minutes approved by the body have to be in writing. Yes?
Does the public have the right to go in to anybody's minutes and just look at all the minutes?
Does the public have a right to go in to look at the minutes?
They just want to look at.
Yeah, I mean, if they want to go to City Hall and look at the records, they have a right to do that under the public records law as well as the open meeting law. They're open. So if they want to, rather than receive their own copy, they just want to review them. They generally can do that. There are, the town, in certain circumstances, under the public records law, can provide a reasonable fee for the amount of work that they have to do to either copy documents and provide them or collect them, and that's all handled by the Secretary of State's office. Any final questions before we conclude? Going once, twice. All right, well, thank you very much. I'll certainly stick around to answer any questions. I appreciate the time, and please feel free to contact our office if you have any further questions. Thank you.